Hello friends, this is Dr. Shashi Agarwal. I welcome you all. Today our subject is business law and the topic is chapter is offer and acceptance, and topic which we are going to cover, that is the essentials of a valid offer. This topic is also available in Hindi at my second channel Shashi Agarwal Economics and Law Classes. If you find my video useful, please do like it, share it, and also subscribe my channel Shashi Agarwal. This is my app, Adusam app, which you could download from Google Play Store. This app provides free study material and free mock test to the students of Commerce, Economics and Management. And it also offers many structure courses. Business law is also available as a structure course. First of all, we should be clear about the meaning of contract. Contract is what? That is an agreement which is legally enforceable. Section 2E defines the agreement, every promise and every set of promise forming the constitution for each other. Agreement means the one party makes an offer and the other party accepts it. And the agreement, then it becomes agreement. And it should be supported by the constitution. And if it is legally enforceable, then it becomes the contract. Section 2B defines the proposal, or we could call it offer, which is made by the one party and the other party accept it. Then it makes an agreement. So agreement means one party makes an offer, the other party accept it, and that acceptance must be communicated to the offerer. Offer is the starting point in the formation of a contract. Section 2A defines the offer. When one party signifies to another his willingness to do, like A makes an offer to B, I wanted to sell my bike for rupees 50,000. Here one person signified to another his willingness to do कि he wanted to sell his bike for rupees 50,000 or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence. When one party makes the offer, the intention is to get the consent of the other party. Like A has taken a loan of rupees 20,000 from Mr. B at a 6% interest, but he did not pay his loan on the maturity date. So B wanted to sue A. A makes an offer to B, please don't sue me. I will pay you 20,000 at 8% interest instead of 6%. So here the person makes an offer not to sue him. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence. In the first case, A makes an offer to B, I wanted to sell my bike for rupees 50,000. So he wanted to get the acceptance from the B. In the second case, the abstinence, here he makes an offer to his creditor that don't sue him. He will pay the borrowed amount at a 8% interest instead of 6%. The person who makes the proposal is called the proposer or offerer. The person to whom the offer is made, we call the offeree. Proposal is an expression of will or intention. I want to sell my bike for rupees 50,000. Here he is expressing his will or intention. A person who is making the proposal expresses that he is willing to contract on the terms which are stated in that offer, provided the other party to whom the offer is made will like express his assent to the same terms. Like A makes an offer that I wanted to sell my bike for rupees 50,000. B said, okay, I will buy your bike for rupees 50,000. Here the one party makes the offer and the second party accepts it on the same terms and conditions which are given in the offer. Section 2A reveals three essential elements There is an expression of willingness to do something or not to do something. And here the offer is made to another person. One cannot make offer to himself. The intention, here the one party makes an offer to the other party to get his consent to such an act or abstinence. Essential element of a valid offer, every proposal must be communicated. If you want to make offer to someone, then it should be communicated to that person. And here, when you are making the offer, then it should be made with a view to create legal relation. It must be definite and certain. It should not be vague. So what are the other necessary points? General offer, specific offer, offer and invitation to offer, standing offer, which we are going to understand in. So kinds of offer, how made? It could be express, it could be implied. Express could be verbal and in the form of written. Implied, which could be inferred from the action and behavior. To whom made? It could be general offer, which is made to the whole world. Specific offer when it is made to the particular person. So how an offer is made? It could be express or it could be implied. Express offer is one which is made by spoken words, which could be orally. When A told B, I wanted to sell my bike for rupees 50,000. And in the written form, when the offer is made in the written form. Implied offer, which is gathered from the conduct of the party or the circumstances of the case. Like you visited a restaurant and you had tea, so it means you have to make a payment because your conduct showed that you have accepted the offer of a restaurant. To whom an offer is made? It could be made to a particular person, it could be made to a particular group or body of person, it could be made to the public. When an offer is made to a definite person, it is called specific offer. Then that person could only accept it. No other person can accept it. When offer is made to the world at large, it is called general offer. So here is the famous case, Carlyle versus Carbolic Smoke Ball Company. A company advertised in newspaper that a reward will be given to any person who contract influenza after using the smoke balls according to the printed direction. Mrs. Carlyle used the smoke balls according to the printed direction, but in spite of it, she had influenza. So it was a general offer. By using smoke balls as per the instructions, she has accepted the offer. An offer is different from invitation to offer. Like there is a advertisement in newspaper. On particular day there will be auction, and you reach at the place where it was advertised to be auction, but there is no auction, so it's an invitation to offer. Displaying of the goods at the shopping window, a mere communication of the information in the course of negotiation, a casual inquiry, a prospectus inviting the public to subscribe to the shares or debenture of the company, a catalogue of goods for sale, prospectus inviting the public to subscribe to shares or debentures of a company, advertisement for tender. So offer is different from all these. So what are the essentials of a valid offer? The offer must be capable of creating legal relation. When the offer is made, definitely the intention behind making the offer is to create legal relation. Like A told B, I wanted to sell my house worth rupees 10 lakh for rupees 100. So here the party, they do not have any intention to enter into legal relation. And the case Balofer versus Balofer, like Balofer was employed in salon, his wife could not accompany him, so Mr. Balofer said कि I will make you payment of 30 pound per month, and he failed to pay that amount. Mrs. Balofer sued her husband and the court decided it was a domestic agreement, the party do not have any intention to create the legal relation. The offer must be certain, definite, and not vague. The offer must be certain, the meaning of which is clear. It should not be ambiguous. Like A, who deals in many kinds of oil, variety of oils, I wanted to sell you 100 tons of oil. Here it is not clear which oil he wanted to sell it. So the offer should be certain, definite, and not vague. In the case of Taylor versus Portington, Mr. A agreed to take the B's house on a rent for £85 provided the house is properly renovated, repaired, and drawing rooms were decorated as per present style. So it is very vague. So it is not a offer. And the offer should be communicated to the offeree. If it is not communicated to the offeree, how will get the acceptance? Like in the case of Lalman Shukla versus Gauridat, D's nephew was missing. He sent his servant P to find him. In the meanwhile, D announced reward. His servant found the nephew and demanded reward. His claim was rejected on the ground that he was not aware of the offer. So he could not claim the reward. An offer may be conditional. An offer may be conditional. An offer can be made subject to certain conditions. And those conditions, they should be communicated to the offeree. It can be accepted only subject to that condition. In case of Thomson v. LM and Railway, A was an uneducated person. He took an excursion ticket on the railway. On the ticket, it was written to see the condition on the back. So one of the conditions was that the railway company would not liable for the personal injury to the passenger. A was injured and A could not recover the damages. So offer may be conditional. Offer should not contain a term the non-compliance of which would amount to acceptance. A makes an offer to B that he will sell his bike to him for rupees 30,000 and said, if I don't receive the reply next Monday, I will assume that you have accepted the offer. The offer should not contain term like this. If it contains term like this, it will not be a valid offer. Offer must be made with a view to obtain the consent of the other. The offer must be made with a view to obtain the consent of the other party. Here you are just expressing your intention, but the objective is not to get the consent of the other party. Then the offer is not a valid offer. Lapse of an offer. An offer may lapse if either the offerer or the offeree dies before the acceptance. If it is not accepted within the specified time, if no specified time is given, then it is reasonable. And what is reasonable depends upon the circumstances. Like in case of there is an offer to buy shares in a company, so 5 months has been held to be unreasonable delay in accepting an offer to buy shares in a company. If the offeree does not make a valid acceptance, like A makes an offer that I want to sell my bike for rupees 30,000. B makes the acceptance that I will buy your bike for rupees 30,000, but I will make the payment in installment. So here the acceptance is with some conditions. So it is not a valid acceptance. An offer can also lapse by revocation. An offer can also lapse if before acceptance it is cancelled by the offerer. Invitation to offer is not an offer. Here the objective is to circulate the information. The goods they are displayed with price tag is invitation to offer. When a person makes an invitation to offer, the object is not to obtain the consent of the other party. The intention is to circulate the information that he is willing to deal with anybody who on such information is willing to open the negotiation with that person. Standing offer, where goods and services are required over a certain period. A firm may invite the tender. So invitation of the tender or giving the advertisement for the inviting the tender is invitation to offer. It is not an offer. So offer for the continuous supply of a certain article at a certain rate over a definite period is called the standing offer. Such offer, though accepted, do not give rise to contract unless an actual order is placed. When the actual order is placed, then it becomes the contract. The acceptance of standing offer has the effect that when the goods or services are required, an order is placed with the person who submitted the tender, and each time a different contract is made. And before placing the offer, the standing offer, the offerer can withdraw his. The offerer could withdraw his offer also. Counter offer. It means the rejection of the original offer and making a new offer. In the case of Hyde versus Lynch, A offered to sell a farm for rupees 1000 pound. B said he will pay 950 pound. So here is a counter offer. A rejected. B then said 1000 pound. A again refused, held there was no contract. So legal effects of the counter offer are rejection of the original offer. The original offer is lapsed. A counter offer, when it is made, it means it is a new offer. Cross offer. When two parties make identical offer to each other in ignorance of each other's offer. To cross offer, do not conclude a contract. D wrote to P on 28 November 1971 offering to sell 800 tons of iron at 6900 rupees per ton. On the same day, P wrote to D offering to buy 800 tons at a rupees 6900 per ton. So it is the cross offer, identical offer. So they are not the offer and acceptance. So they are not valid offer. A statement of price is not an offer. In the case of Harvey versus Fessy, 3 telegrams were exchanged between these two parties. Will you sell your bumper hull pen? Telegraph lowest price. Face to Harvey, lowest price 900 pound. We agreed to buy bumper hull pen for 900 pound for the sum asked by you. So there is no contract because the party was just providing the information. Many big organizations like life insurance company, railway, they have printed contracts. So these are the standardized contracts because they contain a large number of terms and conditions which exclude the liability from the organization. The individual, whether he likes the terms and conditions or not, they have to sign them. So in the recent times, the court wanted to protect the individuals. So they have adopted various protective measures by the aggrieved person, excluding unreasonable terms. If there are special terms in contract, they must be communicated to the offeree at the time when the offer is made. In case of Ole versus Marlborough Court Limited, a hotel put a notice in a bedroom that the owner is not liable for any loss of the client's good. It was held that notice was not effective because it was not communicated to the client while the offer was made to the client.